So, welcome to episode 5, Business Law 2 students, episode 5 of contract formation. All right. So, we talked about a couple of the distinguishing features of the offer under the Uniform Commercial Code, including the permissibility of certain open terms, even in some cases, open price and open quantity terms, right? So here we're going to move on to some of the distinguishing features of acceptance, right? So acceptance is basically the return promise that seals, that sort of provides the consideration, or confirms that the consideration will be provided, and cements the contract. All right. The Uniform Commercial Code permits in response. So if I'm making an offer to buy goods, right, to the person to whom that offer is being made, I'm offering to buy your goods. You can either promise to ship or ship conforming or non-conforming goods. That is your acceptance, right? Conforming or non-conforming goods. In the case of conforming goods meet your obligations under the contract, right? If your acceptance is simply shipping the goods, right? The the shipping of non-conforming goods, while being an acceptance, places you immediately in breach of the contract or not in accordance with the contract's terms, right? And that's UCC 2-206, right? And its provisions concerning acceptance, specifically sub 1, sub B. All right. So whether the goods are conforming or non-conforming is an issue. And so if goods are conforming, they are basically in accord with what the contract required, right? That means that if I ordered 150 packages of pens, black, ballpoint for my stationery store, right? And I receive them, 150 packages of ballpoint black pens, then the goods are conforming goods. If those pens happen to be blue ink, then they are non-conforming goods, right? So the distinction simply places, again, it places in a fact pattern, it places the party who is performing, in this case, the seller of the goods, in the position of potentially being in breach of that. So here, technically, the shipment of the blue pens, is both an acceptance of the offer to buy the black pens and a breach of the contract to supply the black pens, right? The UCC provides an exception. So suppose that you, as the supplier of the pens, say, I am not going to have the 150 packages of black pens because there's been a run on black pens due to the world ink crisis. And so the black pens won't be available for at least another month. But I want to make money this month, and so I can offer seasonably, meaning within a reasonable amount of time, I can offer what's known as accommodation. And in my reply, I would need to say that, hey, we have 150 blue pens, and so by doing that, it would not constitute an acceptance or a breach, but in fact, it would be another offer, right? The shipment of these pens. And so then the power of acceptance would shift again to the person who made the offer to buy the black pens in the first place. In this case, it would be me as the owner of the stationery store. So, or another example, the pharmacy orders 5 cases of Johnson & Johnson 3x5-inch gauze pads from HT Medical Supply, right? HT Medical Supply ships 5 cases of zero form 3x5-inch gauze pads instead, because they had those in stock. The shipment acts as both an acceptance of Merrill's offer and a breach of the resulting contract, right? McFarrell could sue, the pharmacy could sue the medical supply company for any damages as they may be appropriate, all right? So in this case, the medical supply company needs to notify the pharmacy that the zero form gauze pads are the only ones that are currently available. They'll be shipped as an accommodation, right? because we've only got those in stock, and it will basically form like a counteroffer, right? Not rather than an acceptance that results in breach. That's an important, distinction to keep in mind because that's something that actually happens in business every day, right? So the contract then is formed only if they accept the gauze pads, or if I accept the blue pens, or if the party who originally made the offer accepts the accommodation, whatever it might be. Another thing about acceptance, we've, most of our talk generally is about bilateral contracts, but in the case of unilateral contracts specifically, acceptance you must have notification of acceptance, right? Or notification of communication of the fact that you're accepting. In some cases, right? It's more stringent than the common law, right? Which basically doesn't require any notification to the offeror. You just perform, and then you collect your reward, right? But here, if the person who makes the offer is not notified within a reasonable amount of time that the offeree has accepted and begun performance, then the offeror can treat the offer as being lapsed. And that's UCC 2-206 or UCC 2A 2-206, parallel provision, sub 2 in either case. So that's an important distinction, right? If it concerns the sale or lease of goods and somehow a unilateral sort of promise is involved, then you have to notify the person who is making the offer of the fact that you've begun performance. So here is a third important thing about acceptance under the UCC. The UCC dispenses with the mirror image rule in the case of goods. So the way this works under UCC 2-207, if if one party mails another party and says, "I'll sell you 20 Samsung Galaxy tablets," right? If the person who receives the email accepts the offer but says, "No, we want 25 tablets," or "I want a different type of tablet that you have in your inventory," right? Then there is no contract, right? The UCC does away with that. There is no sort of requirement under regard to the sale or lease of goods that it involve a mirror image. And so the way that UCC 2-207 deals with this is it permits an offer to be accepted even if the acceptance includes terms additional to or different from those contained in the offer. That's UCC 2-207 sub 1, right? Then, so there could still be an acceptance. Then the question becomes, what happens to those additional terms, right? And that will depend in part on what the circumstances of those changes are. So if one or both of the parties are non-merchants, then the contract is formed according to the original terms of the offer and does not include any different or additional terms, right? So OfficeSupplyStore.com sells office supplies on the web. Employees of the Kansas City School District ordered $17,642.54 worth of office supplies without the authority or approval of their employer from the website. The invoices accompanying the goods contained a forum selection clause that required all disputes to be resolved in California. When the goods were not paid for, Office Supply filed suit in California. The Kansas City School District objected, arguing that the forum selection clause was not binding. The court held that the forum selection clause was not part of the party's contract. The clause was an additional term included in the invoices delivered to the non-merchant buyer. The school district is not a merchant, right? Therefore, the clause would have become a part of the contract only if the buyer expressly agreed, which did not happen in this case. So because the Kansas City School District did not accept that additional term, then we know that they can't be held to have that been a part of that contract. All right. The rule changes, however, if one or both, if both parties are merchants. So if both parties are merchants, the rule switches up a little bit. So when both parties are merchants, there is this problem that sometimes arises called the battle of the forms, right? Where a transaction might be offered through several iterations, communications that go back and forth, right? And determining which terms are accepted at the time of performance can sometimes be a trick, right? And so the UCC wants to simplify and avoid a fight over the inclusion of terms, right? And so under UCC 2207 sub 2, if the contract is between merchants, right, additional terms are automatically included in the contract. Additional terms are automatically included in the contract. Once more, additional terms are automatically included in the contract unless, right, one of three conditions exists. One, the original form, right, expressly conditions its acceptance, right, on the acceptance of these particular terms, right. It limits acceptance to the terms of the offer, right. Number two, the changed terms materially alter the contract, right. So if I say I want to buy bagels, right, and then they offer me English muffins, I don't know, milk instead. It's like something totally different, right? That's a material alteration to the contract, and that won't be included as an additional term. Or third, when the offeror objects to the new or changed terms within a reasonable period of time, right? So if those other two conditions are not present, right? But I see that these changed terms and I perform, and I sort of notice that, they're asking for something very different than what I offered, right? I can basically raise that, and that will not result in the acceptance of their additional terms, right? So then the question becomes, what is a material alteration to the contract, all right? So if we know that in general, additional terms between merchants are accepted, right? If I add additional terms, right, I'd accept if, in these certain cases, including if there are material alterations to the contract. What is a material alteration? A material alteration will be defined generally by the courts, right? It's the rule again is if the new or changed terms materially alter the contract, the new terms are not included in the contract, right? So a material alteration is the rule, and then we have to know what that rule means, and that sometimes is the hard part, right? But in general, we should keep in mind that if the new or altered terms would involve an unreasonable element of surprise or some hardship upon the offeror, right, the court will hold that the modification did not, or sorry, that the court will hold that the modification materially alters the contract in those circumstances. If there is no hardship or undue surprise, then the court will hold that the modification does not materially alter the contract, right? So that is a principle that I'd like you guys to keep in mind as you go on to answer the prompt